So welcome all to this webinar today, where we'll be speaking about waiver and reservation of rights. We're not speaking today about waiver of insurers' rights to information in the context of duty of fair presentation under the Insurance Act. We'll cover that in a future session, so keep a lookout for that. My name is Jacqui King. I'm a Principal Associate in the Insurance Disputes team, and I'm speaking today with my colleague Ash Patel, who works in the same team with me. This session is being recorded, and whilst you can see us, we cannot see you. We will have time for a question and answer session at the end of this, so if you have any questions, please post them in the question and answer box at the bottom of your screen, and my colleague and Senior Legal Advisor Harriet Strevens will pick them up for us at the end. If we run out of time, we'll deal with them separately after the session by email. So we're going to start today by discussing the basic concept of waiver and look at the two different types of legal waiver. We'll then talk about how insurers can ensure they don't waive their rights under a policy, looking first at reservation of rights, and then other steps an insurer needs to consider carefully to protect themselves from waiver arguments. So firstly, what do we mean when we talk about waiver? Well, McGillivray says, and I'm just going to read the quote on the screen, the abandonment or relinquishment of a right or a defence which may occur as the result either of an election by the insurer or the creation of an estoppel precluding him, the insurer, from relying upon his contractual rights against the insured. So in plain English, that means effectively where an insurer believes it behaves in a way that demonstrates it has given its rights up under a policy. So the sorts of rights we're talking about are those rights to a remedy as the result of a breach by the insured. So avoidance, where you treat the policy as if it has never existed at all. Declinature, where the policy remains in place, but insurers deny liability in respect of a particular claim or group of claims, or reducing an insurer's liability in relation to a claim in some way. Those breaches are generally, but not necessarily, breaches that are sometimes discovered when a claim is made under an insurance policy. I'll now hand over to Ash to talk us through the two different types of waiver.
Thank you, Jacqui. The two different types of waiver are waiver by election and waiver by estoppel. We'll start with waiver by election. Waiver by election is where the insured has breached the policy, triggering a contractual right for the insurer to, for example, avoid the policy, and where insurers are aware of the breach but lose their contractual right by reacting in a manner which is wholly inconsistent or incompatible with the enforcement of that right. So essentially, there have to be three different aspects to waiver by election, which are that there has to have been, one, a breach by the insured, two, actual knowledge of the breach by insurers, and knowledge of insurers' contractual right to elect to do something about it, and three, an unequivocal communication to the insured which is incompatible with insurers' right to, for example, avoid the policy, if the insured is going to be able to prove that insurers have waived their rights by election. Now, the election itself does not have to have been made consciously by insurers. And what constitutes an unequivocal communication? Well, it must be clear and without caveats, and it can be implied or an express statement. What if the communication from insurers is delayed in any way? Well, where the policy is silent, insurers have a reasonable period of time in which to make their choice as to how they wish to proceed. But any excessive delay in that process may be construed as a decision to affirm the policy in the absence of any other explanation. It's worth remembering that the contractual right entitling insurers to act in a particular way, such as to avoid the policy, can only be exercised once. It is permanent and irreversible. Following the decision to use the right or to elect not to do so, the legal right that the insurer had as a result of the breach no longer exists. An example of waiver by election is illustrated in the case of Compagnia Tirrena di Assicurazioni SpA, on your slide now. This was a reinsurance case in which the premium was payable in instalments. The reinsured did not pay the premium, and in response, the reinsurer sent demands for payment. The reinsured submitted claims to the reinsurer, which the reinsurer didn't meet. The court held that the reinsurer had elected not to use its right to avoid the treaty following the breach by demanding payment of the premium, an act which was wholly inconsistent with avoiding the treaty. We'll now move on to waiver by estoppel. Thank you. The major difference between waiver by election and waiver by estoppel is that waiver by estoppel involves the insurers making a representation which the insured then relies upon. Waiver by estoppel occurs where the insurer makes a representation to the insured that it will not exercise a right or rely on a defense under the policy. The insured relies on that representation such that the court considers that it would be unfair to the insured if the insurer was subsequently allowed to employ its contractual right, having represented that it would not do so, even though its legal entitlement remains unchanged. So in order to create the estoppel, there must be, firstly, a representation by insurers, which can be expressed or sometimes implied by their conduct, orally given or in writing. And unlike with election, that communication can actually take place before any breach has occurred. And secondly, there must be reliance. As already said, here is the major difference between the two types of waiver. The insured's behavior also plays a role in its creation. After the insurer has made a representation, the insured must rely on it in order to complete the constituent parts of the equitable remedy. Reliance involves the insured changing its position as a consequence of the representation. So, for example, where the insurer has represented that it will not avoid the policy as a result of the insured's breach, the insured might rely on that representation by not taking out alternative insurance in the belief that the policy will not be avoided. And thirdly, the court has to consider whether it would be inequitable for the insurer to be allowed to renege on its representation because the insured has acted in reliance on it. Therefore, even though the legal right still exists for the insurer, it's prevented by equity from using it. The final difference between the two different types of waiver is that estoppel can create a temporary situation, whereas the effect of an election is always permanent. For example, where the representation was that the insurer would refrain from exercising its rights for a definite period of time, the estoppel would be time limited. By way of illustration, I've referred to two cases on the slide, which we'll now look at. The first is Barrett Brothers Taxis Limited. The facts of this case concerned an insured driver whose insurance policy required him to immediately send his insurers a notice of intended prosecution on receipt. Following an accident, the insured was sent a notice and a summons, but he failed to send either document to his insurers. In fact, it was the police who wrote to his insurers and notified them that the insured would be prosecuted. At this point, insurers wrote to the insured asking why he had not sent on the documents as required. The insured ignored the request and instead attended court and pleaded guilty. When insurers failed to meet the claim, they relied on the breach of the notification clause by the insured. However, the court found that the insurer's letter to the insured was a representation that they did not intend to enforce the requirement for the insured to send them the documents because they didn't ask for them. The insured relied on that representation and pleaded guilty. The insurers were thereby stopped from avoiding the policy. The final case that I want to talk about today is Cosmar Villa Holidays plc. This case concerned a public liability policy for a company renting holiday villas. The policy required notification of both an occurrence, i.e. an injury sustained by one of the guests to the holiday villa, and of receipt of any claims. Now, unfortunately, a visitor to the holiday villas who was using the swimming pool had a very bad accident while doing so. and the insured failed to notify that occurrence. But over a year later, when the visitor's solicitors submitted a claim, the insured did correctly notify that to insurers. Insurers took over conduct of the claim, but they also requested information from the insured, and insurers subsequently repudiated the claim for the breach of the notification requirement. At first instance, the court found that there had been an election and the insured was successful. However, on appeal, the court considered the difference between election and estoppel in detail and found that this breach was a matter of estoppel, but that because there hadn't been an unequivocal representation by the insurer, there was therefore no remedy for the insured. Having finished this part of the presentation, I'll now hand you back to Jacqui, who will be talking about reservations of rights.
Thanks, Ash. So one of the obvious means by which an insurer can protect themselves from being found to have waived its rights is by ensuring it reserves its rights. So when thinking about reservations of rights, insurers need to consider, firstly, the timing and wording of the reservation itself, and secondly, to carefully think about the steps taken after a reservation of rights is issued. So firstly, when should a reservation be issued? Generally, it's at the point where the insurer is aware of the insured's breach and its entitlement to a remedy. That might not be when a claim is made, and it's not an immediate requirement. Insurers are entitled to sufficient time to investigate. Having said that, once an insurer knows about the potential breach and the possible remedies, it should reserve rights before steps are taken in relation to the policy or the claim itself. And we'll discuss that a little bit more on the next slide. You might also need to repeat the reservation as and when you do take steps in the policy or claim. And how should a reservation of rights be issued? Well, it should be in writing, clear, and unambiguous. If it isn't, insurers are unlikely to be able to enforce it. For example, if an insured notifies a claim 9 months late, and insurers simply complain about the delay, but don't expressly reserve their rights, a court is unlikely to imply that they have reserved their rights. And what about the extent of the reservation? Should it be general or specific? This can be quite a difficult balance that needs careful consideration. On the one hand, you have a potential breach for which insurers want to reserve rights, but there might be other things out there that insurers don't yet know about, meaning insurers would prefer to reserve their rights more generally. But insurers will also be concerned about broker relationships and other commercial considerations. It is possible to reserve rights in relation to specific issues or breaches, and it can be helpful to do so to establish a transparent position with the insured. However, if the reservation is too specific, insurers risk inadvertently waiving their rights to rely on other breaches. So generally speaking, we'd say if there is any sense that there might be more issues out there, it's worth reserving rights more generally. This will, of course, always depend on the facts of each case. So whilst insurers will be considering their client and broker relationships, other commercial considerations, it's really about balancing everything and making sure that if insurers think they might want to rely on a breach or avoid or decline a claim, they take steps now to protect their position. So moving on to other steps, a reservation of rights is not enough if an insurer then behaves in a way that is inconsistent with that reservation. So to put that another way, insurers need to be careful what steps they take when issuing a reservation, after issuing a reservation, to ensure they don't then render that reservation unenforceable. For instance, agreeing endorsements to a policy or accepting a premium in relation to a policy potentially sends a message that insurers consider that policy remains live, which would be inconsistent if insurers were considering avoiding a policy and treating it as if it had never existed. Even relying and discussing the operation of the policy suggests the policy remains live, and that could jeopardize a subsequent attempt to avoid. Paying defense costs or instructing legal counsel or making interim payments might send a message that insurers accept a claim under the policy, which would be inconsistent if insurers were considering declinature. Similarly, requesting information in relation to the adjustment of the claim itself might suggest insurers are considering the details of the claim with a view to making a payment. Now, none of these steps are conclusive or fatal, and it's perfectly possible and quite common to take some of these steps without waiving insurers' rights. But it's important insurers do so in the right context to make sure there's no room for argument. One key element of this is to make sure all parts of the insurer team are communicating effectively when issues of breach or potential avoidance declinatory arguments arise. Claims teams might well be considering coverage aspects in detail, but it's important for those issues to be communicated to the underwriting team to ensure no decisions are taken in relation to endorsements or renewals, etc. So just to summarize a few key takeaways, there is a high-level proof in relation to waiver. Waiver by election requires an unequivocal communication, and waiver by estoppel requires both representation and reliance by the insured. It's also quite fact-specific. All situations will depend on the fact of each case, and it's rarely, if ever, a case of one size fits all. Reservation of rights are important. Make sure it's clear and repeated if necessary, but it's not foolproof, and the further steps insurers take need to be considered carefully. And finally, collaborative working between claims and underwriting teams is key to ensure a consistent approach. So that brings us to the end of our session today. I'll now pass the baton to Harriet to consider any questions.
Thank you very much indeed, Jacqui. We've got time for a couple of questions, so if I may direct this one to you. You don't mention affirmation at all. Where does affirmation fit into all of this?
So put very simply, affirmation is a type of waiver by election. Effectively, an insurer elects to affirm the policy rather than it electing to deny or avoid a policy.
A straightforward interpretation of English then?
Yes.
Thank you. Ash, if I might ask you one question. What if an insurer doesn't avoid a policy but then discovers new facts that would have changed the decision? What happens then?
Yes, well, if further information comes to light which the insurer didn't have previously, that could create a new right to avoid the policy because they didn't have all the information to hand at the time of the affirmation. But it must be said that would be highly fact specific, and the further information couldn't simply just be additional detail about the matters previously known about the original breach. It has to be genuinely new.
Thank you, Ash. Just one general question before we sign off from the questions and answers. If there's not enough information to assess a claim, do we think that an insurer can state that cover is not confirmed until that information is provided? Do you have a view on that, Jacqui, at all, or not?
I think if there's a concern, then insurers should reserve rights and take the time to investigate and really keep their options open if there's a concern. Does that answer the question?
Yes, it does. I think it's on the one hand ambiguous, but on the other, if there's any uncertainty at all, one needs to be much more careful to be specific about what your own position is as an insurer, as I understand the position.
Yes.
We have a raft of other questions, but no time in which to answer them. So I'll pass the baton back to you on the basis that those that we can answer by email, if emails have been provided, we will certainly do so. Back to you, Jacqui.
Thanks, Harriet. So our next cover talk is on the 28th of April, Thursday the 28th, when my colleagues Daniela McGowan and Sophia Haniff will be speaking about insurance risks in the construction arena. And finally, we invite you please to complete our questionnaire at the conclusion of today, as this does guide us in ensuring that we choose topics you would like to listen to. We hope to see everyone on the 28th of April, and thank you for listening.
Thank you.